Hi everyone, so we are back. Our technical issues are fixed now. We are back at our National Conference of Private and Data Protection Privacy Romania 2021. As I told you a few minutes ago, our next guest is Mr. João Miguel Gabriel, and his presentation is about the DPO independence, how to be independent against national law. João, please.
Thank you very much, Diana, for the presentation, and thank you for the Association of Data Protection Officers of Romania for this invitation and this whole event, which is great. We've seen great presentation from lots of different countries, and now it's my time to say hello from the other side of Europe, from Lisbon, where it is a rainy day, unlikely for Portugal, but well, it is winter here. So today I'm going to talk about the DPO independence, how to be independent against national law, because in Portugal we have a problem. The law that tries to implement the data protection, the GDPR, I know it's strange to have a law that implements the GDPR, because the GDPR is a European regulation, so it does not need to be implemented by national law, but our national law says so. And our national law says that the DPO adds some functions and capabilities to the DPO. We've heard Finton's requirements for the data protection officer, and now I'm going to try to present you some other requirements that the law is trying to impose on us. So, but I know that we are reaching lunchtime, and I'll try not to talk about laws and data protection officers and everything. I'll talk about what's on the menu, and I'll try to talk about a little bit about food, because that, I believe, that is all that we desire at this moment. So let's start with the GDPR tasks. The GDPR requires the DPO to inform and advise, to monitor compliance, to provide advice, both regarding the data protection impact assessments as regarding data breaches, and to cooperate, meaning to act as a contact point to the supervisory authorities on issues relating to processing, including the prior consultation. Furthermore, we also need to drink when we are having a meal, so the GDPR also adds to these functions the capability of data subjects to contact the data protection officer with regard to all issues related to processing of their personal data and to the exercise of their rights, meaning that the DPO will also be kind of a psychologist that could be contacted by the data subjects. I mean, we have a lot to do. We have a lot on our plate, and we have a lot on the menu. But we need to cook the menu. So what are the means, the means that the GDPR gives the DPO in order to pursue those functions? So first of all, the companies must provide the DPO with resources, meaning both training resources as an office space, a computer, but foremost, the DPO needs to be involved properly and in a timely manner in all issues which relate to the protection of personal data. As I said, it needs to be given support, the resources necessary to carry out these tasks. But one of the most important, confidentiality is also important, but one of the most important tools that the DPO has is the independence. He shall not receive any instructions and shall not be dismissed or penalized by the controller or the possessor for the performance of his tasks. And what does this independence mean? It means that the DPO should not receive any instructions, shall not be dismissed or penalized by his functions, and his tasks and duties do not result in a conflict of interests. Let's talk a little bit further about this. What does it mean for a DPO not to receive any instructions? It means that his advice should be independent. He should take into account the GDPR, any privacy laws, and he should take into account the legal rights of the data subjects. Also, the need of compliance of the controller or processor. He should not take into consideration, at least directly, the financial standing of the controller or the processor, nor any other considerations that are not privacy related. The DPO obviously should be an asset to the controller or the processor. However, the only way for him to be an asset is to be independent in his counseling. So he should not receive any instructions. Take, for example, me as a DPO, I am a DPO, my company is a DPO in several controllers or processors. We are required to assess a data protection agreement. Should I say, should I advise the company not to take this agreement because the chief financial officer said we should not take it? Should I accept minimum requirements for talking or for the processor to answer to us that are further than the 72 hours? Taking, for example, a data protection agreement, I'm the controller, I'm representing the controller, and the processor proposes to have 2 weeks to notify a data breach. The CFO says they have a very good price. If we lower this requirement, the price will go up. Should I listen to the CFO regarding this? Obviously not, because 2 weeks is way too much to be notified by a data breach from the processor. So the DPO really should be independent. If he is not independent, his functions, his obligations will be wrongdoed. Further, he shall not be dismissed or penalized by his work. I mean, we should not be taking instructions. What happens if we do not comply with the instructions that they are giving us? Because in the end of the month, we know who pays us. It's the controller, it's the processor. So what to do if we go against them? So we have this legal right not to be dismissed or penalized by our opinions. It doesn't mean that we are not under a contract or that we have not duties, and not to comply with those duties does not have repercussions. It does have repercussions. However, those repercussions cannot be connected to what we have said in the course of our functions. Kind of like what we have there with employees representations and syndicates, so unions. On a third way, tasks and duties must not result in a conflict of interests. The DPO must be as independent as to give advice to what the controller or the processor is doing, which means that if I'm the one deciding what the controller and the processor is doing, I'm giving advice about what I am doing. This trashes the independence criteria. For me to be independent, I need to not be the one deciding. I need to be giving advice to others that have decided. Otherwise, I would not be independent. No one is a good judge in his own case. So this is what the GDPR is giving us to eat. And you know that an apple a day keeps the doctor away. So if the DPO does his functions with these tools, he will be successful. However, let me present you to the Portuguese food. This is cozido. It's a very traditional Portuguese dish. It has all kinds of meat, from chicken, beef, pork, mashed with beans, cabbage, potatoes, Portuguese sausage. It has everything. It's very good and it's very nice. However, it's a little bit more than this apple. What do I mean by the Portuguese dish has more in its plate than the GDPR? It means that the Portuguese data protection law requires the DPO to provide some further services, meaning the DPO must assure auditing. The DPO must train users, and the DPO must assure contact with the data subjects. The question is this too much for our stomach? Let's give it a little bit of thought. So, if we have some obligations under the GDPR and we have other obligations that should be added by the Portuguese law, how should we interpret these new obligations? Should we eat apples and cozido, or should we interpret the Portuguese dish as a compliment? The only way to make this interpretation of the Portuguese dish to be a great meal together with the GDPR is to take into consideration the limits that we were talking about, namely the limit of independence. And we should ask ourselves if the DPO is truly independent, if he assures the auditing. How can I assure an internal function of the controller or the processor whilst being independent? The question is to try to complement the EU GDPR requirements with the Portuguese requirements and try to assure the independence of the data protection officer while complying with Portuguese law. Marius or Diana, I need to have access to the presentation, or you can forward the okay, great. So, as I was saying, Portuguese law requires the DPO to assure auditing, to train users, and to assure contact with data subjects. How can we perform these tasks whilst maintaining independence? So, in order to assure auditing, the DPO should not make the audits himself, because the auditing function should be something that the DPO should take into consideration whilst giving his privacy recommendations. So the DPO should counsel, should advise how the internal audit should conduct his audits regarding privacy considerations, regarding the requirements for the GDPR. So the DPO should, however, ensure that the internal auditing has in its controls privacy requirements, meaning that when the internal audit performs the auditing, he will also be asking privacy considerations. Same question goes for training. Should the DPO train the users himself? My considerations is that training the users and having a training program is something that is the function of the data controller and the data processor. So how should the DPO train the users, as the Portuguese law says, and maintain his independence? How should the DPO advise regarding the training program and still comply with Portuguese law? The same considerandums apply, the same thinking and same logic applies as to internal audit. The DPO should look into the training program and should include privacy training within the company's training program that is already in place. And for that, I thank Mr. Punit for his earlier presentation, because he gave lots of hints on how to do it successfully. Finally, how should the DPO assure contact with the data subjects and still maintain his independence? Shouldn't it be a conflict of interests? For example, the controller is the one who should answer the data subjects. How should the DPO have this function to assure contact with the data subjects if it is the task of the controller to answer to data subjects' requests? It is my opinion that the DPO should function as a bridge. He should take into consideration the requests that the data subjects ask him, should send them to the controller or the processor in case of processor help, and then should get back the controllers and processor answers and should say to the data subject, look, here is the controller's answer, and here is the company's answer to your request. The DPO should not answer himself to those questions, okay? If he does it, he will result in a conflict of interest because it is the controller function to answer the data subjects, not the DPO. So in the end, and we are all eager to lunch, if we're not careful on how we eat, we'll end up as my son with the face all messed up. So we need to be careful how we interpret our national legislation in order to make this interpretation according to the GDPR. We cannot have national legislation that goes against the GDPR. So if for some reason the DPO functions and obligations go against the GDPR's requirements of independence, we should not take those national requirements into considerations. But I know that this is theory, and what you do in real life feels a little bit different. And I know that the DPO should not make any data protection impact assessments, but it is very hard to say no to the client that pays us in the end of the month. So if you're giving a little bit more of advice than you should, I would not tell the authorities, but take into consideration that you are running into a liability. Thank you very much for your time, and I'm sorry for the technical problems. I believe there are no questions, so I get back to you, Diana.
Thank you so much, João, and we really appreciate that you used some personal pictures in your presentation. Very, very cute.